Please be seated, everyone. We are now ready for the oral argument of Law Office of Shearer versus Iowa District Court for Fremont County. Mr. Shearer, you may begin.
All right, thank you, Your Honors, and may it please the court. I'm Shawn Shearer. I'm here pro se on my behalf. I'm also here representing my law firm, the Shearer Law Office, PC. Mr. Spohr, the other plaintiff, has retired. He's not here today, but the last few briefs he signed pro se after reviewing them, and I think I'm fully capable of answering the questions that should arise here. This is a writ of certiorari action to review a $30,000 sanction issued by Judge Nelson, Fremont County, in a case Jennings et al. Versus Fremont County. And the rule is de novo, and it can be modified or vacated. What happened in Jennings was all the claims were dismissed on a motion to dismiss. That dismissal was appealed to the Iowa Court of Appeals, and two of the claims related to Open Meetings Act claims were remanded back to the district court, and we've got a trial scheduling set. Now, the reason for the complication is that this is related to a commercial wind project that was spanning the border between Fremont County and Page County, with about 30 wind turbines going to be constructed on each county side, which required both counties to go through the process of approving the project and then issuing their own building certificates eventually. Page County and Fremont County were at different points in the approval process. Case Hunter versus Page County was filed first in September of 22, and that was removed to district court, and then that proceeded through a motion to dismiss process. The Fremont County case was then filed in January of 23, and about 2 days after the filing of that petition, the decision from the federal district court was issued with the dismissing all of the claims in the Page County case. That was then appealed to the 8th Circuit Court of Appeals, and that whole time the Fremont case is proceeding on its own course. And when the 8th Circuit issued its decision for the Hunter case in Page County, it dismissed all the claims, but it noted that the Iowa Meetings Act claims that were included in the Page County decision might have survived under Iowa's more lenient pleading standards, but they applied the federal pleading standards to it. The other claims, two of the panel at the 8th Circuit decided that the case was moot. One of the panel decided the case was non-justiciable because it had never been ripe. As a result, the 8th Circuit affirmed the dismissal of the open meeting claims, and it vacated all the other dismissals as if they never happened, and Hunter on those issues no longer precedent under federal law.
For the federal case, was the ripeness issue one of the issues that was presented by the parties, or is that something that Judge Colleton kind of came up on his own? With respect to the Hunter case, when it got to the 8th Circuit, Judge Colleton concurred on the basis that he believed that it was not ripe. Was that an issue that was briefed by the parties, or do you know?
Mootness and the ripeness issues were raised sua sponte at oral argument. Neither party briefed those. And the mootness came out of, while the appeal was pending, Page County had adopted a moratorium, and so they decided, and those judges decided with the moratorium the issues as to the meaning of how the wind ordinance and zoning ordinance interacted was no longer justiciable. There was no case in controversy, given that the moratorium was in place.
Timing. So the district court sanctions order references the Hunter case, correct? Which is the case that was removed
Federal court, yes. And
just after the petition and other documents were already filed in this case.
case came out, we looked at it and then filed an amended petition in Fremont County, eliminating several claims that we knew were clearly implicated by Hunter's analysis. We had made in Hunter. That case was filed, I believe, 13 days after Shenandoah Hills had received approval of their application. We were making an equitable estoppel and tolling.
Or district court case, correct? The Judge Pratt's
Decision. And we were making an equitable tolling claim on the 30-day writ of certiorari because of the closeness in process and for other facts, and that was rejected. And so I went and removed the arguments related to the Fremont County application because it was much more, it was further late than what was in Page. So we eliminated those claims and continued on proceeding with the Open Records Act claims in Fremont, some claims in Fremont that did not exist in Page County, things such as a failure to read the wind ordinance 3 times as required by Chapter 331, issues, and the issues related to supervisor conflicts were different because of different supervisors.
form of the sanctions order. Is there anything in the rule or the statute that requires more specificity on what was sanctionable than what the district court judge did here? I've never seen a judge just say, you know, make a list of all the filings and say all of these are sanctionable. And if we're going to do it that way, it seems to me the fact that you're going back for trial on some of the claims indicates maybe that they weren't frivolous in their entirety. So is there anything in the rule that requires some specificity, or is this compliant with the rule? What is your reading?
Rawletter and Barnhill, where this court has stated that the district court needs to make specific findings on 4 factors: the reasonableness of the attorney's fees, the amount of fees to deter, the sanctioned party's ability to pay, and factors related to the how bad the violation is. And that goes to deciding the amount of the sanction. But in deciding whether there should be sanction liability, I think the court needed to go through Rule 1.413 and its standards, you know, was there, and find evidence and make factual findings.
Would agree that as to the arguments that Judge Langholz raised in his separate opinion, any claims that are supported by those arguments wouldn't be frivolous. I mean, his opinion isn't frivolous, is it?
The special concurrence or the federal concurrence? Yeah. He said in an appropriate case that these claims might be right on the
I actually think you can project a little bit more from what he said, but I'm going to wait and talk to the other side about that.
Now, Fremont is moving on to the actual issuance of the building permits, and we've filed an appeal within 30 days of that, and I think that's the case that he's talking about in the concurrence that says in an appropriate case, the issue of the conflict between the zoning ordinance and the wind ordinance, with the wind ordinance authorizing these turbines, but the zoning ordinance having a 2.5-story construction limit and no permitted use in the zoning ordinance. And what Fremont County and Page County did, they adopted these independent wind ordinances under 331, the home rule, but nowhere in those did they specifically amend any of the zoning ordinance provisions. And that special concurrence also talks about, he did not believe what we called the general repealer provision of the wind ordinance, which is just a general statement that all ordinances in conflict with the wind ordinance are hereby appealed. And our position is that's in violation of 331-2044, which in the home rule, which says amendments need to be specified. And he, in his concurrence, he says he believes that a general repealer like that is ineffective. And in Fremont County, you have a unique situation that you didn't have in Page County, is that back when they were building all the cell towers in the mid-90s, they adopted a cell tower ordinance separately under 331, but it specifically went through and identified which portions of the Fremont County zoning ordinance didn't apply to cell tower constructions. In the case of adopting the wind ordinance, they didn't do that. They simply put in a general repealer that says anything in conflict is repealed. And that's the issue on that he says in an appropriate case, he would rule for us.
Standard or review, I think you mentioned we could modify or vacate the sanction, but are we not reviewing the sanction amount and the sanction violation finding for abuse of discretion?
I think it's de novo. This is a different petition. It's not directly appeal of those. That you review the record anew and determine whether the sanction was appropriate or whether the amount is excessive.
Would that have a chilling effect on lawyers and citizens willing to challenge projects like this?
Be a significant deterrence. I won't be doing it again if that's the sanction, and the sanction is higher than the fees I charge my clients on this case, and if the penalty for losing a motion to dismiss is $30,000, I think that will deter meritorious claims from being brought, especially if it's a situation like this where the penalty is, lawyers are putting in their own funds to fulfill the penalty, and the fees earned on the case don't even reach that amount.
On that point, how would you calculate an appropriate sanction?
It's the amount, whatever it is that's sufficient to deter, and frankly, the event subsequent to just the entry of the order, it causes you get a disciplinary board, a complaint opened, an audit of your IOLTA account. And that's just from the mere issuance of it before any decision comes out of this court. I think this might be part of the reason Mr. Spohr retired, and I think there's a lot of stigma to it that gets attached. I've heard about the existence of these sanction proceedings in other cases, and use sort of. To kind of impugn me in a way that loses credibility before the courts. And in my view, with Hunter on appeal, and if we had done what was demanded of us by Shenandoah Hills, which was completely dismissed Jennings, we would have been already past the statute of limitations. There would have been no chance for my clients to challenge the entry of the road use and decommissioning agreements, which weren't in the Page case, and Hunter didn't talk about those. So we had unique claims and circumstances. Hunter was on appeal, and we were arguing that Hunter wasn't binding. It's a federal district court decision interpreting Iowa law in an area where there is no opinion to evaluate Iowa Code 335-204 with telling.
Question, your time's about up. Am I correct that this sanction was entered for, in a sense, you didn't get any warning? Were there any warnings from the court, hey, you're getting close to a line here, you need to knock it off? A lot of times a judge will exercise it because it's a heavy hammer to drop sanctions.
Received, when the Hunter decision came out, we received a letter from Mr. Dublinsky making a 1.413 warning. We then amended the petition to try to address the Hunter issues we thought were applicable. We removed some claims. I never even heard from Mr. Dublinsky after that the amendments weren't sufficient, and then they filed this motion for sanctions on the last day possible after Judge Densland had retired and the new judge had been identified. Thank you, Your Honor.
Mr. Leonard?
Thank you, Your Honor. May it please the court. I'm Brant Leonard with Frederickson and Byron. I'm here today representing Shenandoah Hills Wind LLC, or SHW, as we've called them in the briefing. I have talked to Mr. Livingston, who represents the county, about how to divide these 15 minutes we have. He's ceded his time to me, so I'll be up here for the entirety of the 15 minutes, unless you might have a specific question for him. I want to start with the standard of review in this case, which is
Aware of the standard of review that it's abuse of discretion. But I want to get back to kind of the petition, because that's what we're talking about. The petition is supposedly frivolous. So as I read counts 1 and 2, they ask essentially for a declaratory judgment that the wind ordinance, the zoning ordinance is still in effect, notwithstanding the wind ordinance, which is the point that Judge Langholz made in his concurrence, and therefore construction cannot go forward if it doesn't comply with the zoning ordinance. What's frivolous about that claim?
I think, well, a couple things. One, it's not just that they're not just arguing the zoning ordinance is still in place. It is for any other use. But a couple of things. The wind ordinance is the newer, more specific ordinance. Obviously, it regulates specifically wind turbines, wind generation facilities, while the zoning ordinance regulates other items within the county. They've also challenged in those counts the county's authority to enact that standalone or home rule ordinance.
Is good, but I'm just reading the last two paragraphs of Claim 1. Even if the wind ordinance was a valid act of the board, it did not specifically and legally amend the zoning ordinance, which is the argument that Judge Langholz agreed with. Therefore, the more restrictive use and height limitations of the zoning ordinance govern over the terms of the wind ordinance. Petitioners request declaratory judgment that regardless of the legality of the adoption of the wind ordinance, the construction remains prohibited by the zoning ordinance. What's frivolous about that?
I mean, aside from the fact that it's, as the Court of Appeals found, it's brought 916 days late.
Wrong about that, because it's a declaratory judgment. If the zoning ordinance remains in effect and the wind ordinance remains in effect, but you're not challenging the wind ordinance, which is what they say there, you're just challenging the construction as violating the more restrictive terms of the zoning ordinance. That's timely, isn't it?
I think in that case, the argument is that the zoning ordinance trumps the wind ordinance. And
Ordinance didn't validly amend the zoning ordinance, which is what Judge Langholz indicated in his concurrence, and I thought he raised a pretty good point.
his concurrence, I guess I have to disagree with respect to how he phrases what the general repealer does. I don't think that by saying in this ordinance that it repeals all ordinances and parts of ordinances in conflict herewith means that it repeals all other ordinances, which seems to be what he's saying. I don't think that's a fair way to interpret that.
At that point, we're not in the realm of something that's sanctionable, are we? I mean, a judge on the Court of Appeals raised the issue, right?
As the Court of Appeals found in general, it comes under certiorari and it's therefore late. But even then,
Late. I don't think 3 and 4 are late either. Here's 3 and 4. It says, illegality and invalidity of road use and decommissioning agreements. Now, they went to court within 30 days of those 2 events, correct? So their argument is that those agreements are illegal. That's. I mean, you may not agree with it, but it's timely. It's not untimely.
extent that on its face, they've alleged things in those 2 counts that those agreements had to contain certain terms that the ordinance simply doesn't require them to contain.
Trial date right now.
New,
Date on open meetings claims or no? What?
know it off the top of my head, I'm sorry.
That was in the petition, right? Those claims? So help me walk through this then. The district court didn't make any specific findings as to which counts were frivolous, which legal arguments were frivolous, which facts were not well supported. The district court just said the petition itself is sanctionable. And now we're going to trial on some claims in the petition. So how can both of those things be true?
So the claims that were saved, the Open Meetings Act claims that came back, there are 3 of them. There are 18 claims that were dismissed as frivolous or failing to state a claim. This court has recognized before that simply because there might be some legitimate claims included with some non-legitimate claims, that can still constitute sanctionable conduct.
But isn't it incumbent on the district court to make that distinction? The sanction order just says the court finds the following filings sanctionable. And then it's a bullet-pointed list with no finding of which claims are frivolous, which facts are not well supported. And if the district court's going to do it on a kind of whole filing basis, how can the petition be frivolous if you've already lost on appeal and now you're getting ready for trial on 3 of the claims?
Frivolous to the extent of the 18 counts that were found frivolous.
I mean, once you get in it,
Right? I mean, the district court did not make a finding on counts that are frivolous. It said it said the following filings are sanctionable. And then it just listed petition, which now we're going to have a trial on the merits that you may lose.
And a petition can still be a sanctionable filing, even if it contains some claims that are meritorious.
just isn't Justice McDowell have a point? Then you need to go in and say what's frivolous and explain why. I mean, like I said, I think there are a number of claims in there, not just the Open Meetings Act, that are not in themselves frivolous. They may have been dismissed by the Court of Appeals. I'm not sure I agree with their reasoning because I think some of them are timely. But don't you have to go claim by claim? If you're going to ask something extraordinary like sanctions, you have to really get a little more granular.
I mean, the court at that point, Judge Nelson, is relying, I think we have to assume, relying on the ruling on the motion to dismiss. And so that's where, his reasoning as to what it's a unified court, his reasoning for what claims are indeed frivolous is found in the ruling on the motion to dismiss, which...
Why? It's a federal district court judge, right? On the Hunter case?
About
What's your best starting point? Which claims are the most egregiously frivolous?
those that actually sought relief by certiorari and are clearly, in some cases, years late. Also those I believe it's 3, perhaps it's 4 claims, I'd have to look back at my chart, that seek to invalidate the ordinance or actions of the Board of Supervisors for failure to consider the comprehensive plan. Counsel points out there's no specific case law on that. A simple review of the statute shows that the statute relates to zoning ordinances taking account of the comprehensive plan.
$30,000 is the minimum amount necessary to deter these kind of challenges. Why is that?
You know, any number, there's not going to be a perfect formula to how to pick that number. We do know that the primary purpose of sanctions is to deter future conduct, but there's also a secondary goal, and that's to provide some compensation in the case where a party's been forced to incur substantial legal fees. And so, you know, the cases from this court, $30,000 was a recent one, $25,000 in Barnhill. But then there's a case out there with $1,000 where Justice Waterman has dissented to say, you know, $1,000 amounts to a slap on the wrist. That's probably not a deterrent for lawyers, particularly this day and age when that's probably 2 or 3 hours of work for a lot of lawyers. So I do think $30,000 is the minimum amount necessary. It's in line with the $25,000 in Barnhill, adjusted for inflation. It's the same as the $30,000 in some other cases. So I do think that's appropriate. I do want to touch on that. There's some argument about not having individualized billing entries in support of the motion for sanctions. I guess my point on that is the point of the sanctions order primarily is deterrence. It's not to find the exact amount of reasonable attorney's fees as an award as it would be in a case involving you know, compensatory attorney's fees in a contract or in a statute that authorizes recovery of attorney's fees.
Wind projects are fairly contentious, and you guys do a lot of work in that space. Has your firm sought sanctions against other lawyers relating to wind farm litigation?
Not to my knowledge in the state of Iowa, not to my knowledge, period. But I would only be able to speak to it in the state of Iowa, really.
Concern that affirming this sanction award would have a chilling effect on advocacy of citizens and lawyers who may want to challenge these massive projects?
I think it has a chilling effect necessarily on the parties. This sanction, of course, is against the attorney. And parties are still going to want to challenge these, I assume, but they should do that through vehicles that state legitimate claims. There's been many of these cases. This is the only one, to my knowledge, we've sought sanctions on, and many of them have challenged timely by writ of certiorari or by other mechanisms these projects in other ways. Issuing a sanction in a case where 21 counts are asserted and 18 wind up dismissed is perhaps not the way a lawyer should go about advocating for a client.
On the other side, or it could just be really good lawyering on the other side.
Point about that you had sent a letter, I don't know if it was you, but had sent a letter of sort of warning, so to speak, and then they amended their petition, and then there was no future warning, and why that was?
So there were actually 2 letters. There was a letter written in the beginning of the Hunter case, and then when Hunter was decided, the second Rule 1.413 letter was written, and in that letter, it's part of the record. I mean, it expressly states, we believe this is sanctionable, and we will seek sanctions at the conclusion of the case. So the idea that we somehow purposefully delayed is not accurate, and I think it's only reasonable that you would seek sanctions at the end of the case rather than in seriatim during the case.
Begins of the prior dismissed case in terms of sanctions.
Hunter case? Yeah, so I acknowledge Hunter's not controlling on the court, in a strict sense. It is persuasive authority.
In any sense. No district court judge is obligated to follow the decision of a prior district court judge, period, right? Okay, so why is it sanctionable to continue with litigation because some other district court judge disagreed.
Of authority. I think it's all the more persuasive in a case like this where it's the exact same wind farm in a neighboring county with a nearly identical ordinance. It certainly goes to whether or not that lawyer is on notice that his claims may not have a legal basis to have a federal court order dismissing them. So while it's not controlling, it certainly goes to whether or not the attorney is on notice of whether or not he needs to do a further investigation into the law.
Troubling, right? I mean, if you look at federal circuit courts, there are circuit court splits. There are splits among district courts. I can think of 100 different kinds of cases where state district court judges come out differently on the exact same issue. And I'm a little reluctant to say that you're treading on sanctions territory because you persist with your litigation because a state district court judge ruled against you on a similar case. I don't know. I find that very troubling, and I guess I'm looking for assurances from you, to Justice Waterman's point, that we don't end up chilling advocacy and zealous advocacy just because one district court judge ruled one way.
I don't think the sanction relies entirely upon Hunter, the district court decision in Hunter. The district court decision in Hunter relies itself on Iowa case law, including Mathis, including with respect to the cert claims, Christensen, Perkins, claims that or cases that we often look to with respect to certiorari and issues of municipal law.
Well, I mean, I have a lot of respect for Judge Pratt. He's an excellent, excellent judge. This is a published opinion. Now, from what I know, normally a federal district judge doesn't send in their opinion to be published if all it's doing is rejecting frivolous claims and deciding things that are 100% settled and nobody needs to go read it for any purpose. I mean, Judge Pratt decided that the decision was significant enough it needed to be published. Not precedential, but it needed to be published. Isn't that significant?
I mean, I think it has significance. I don't know necessarily if that cuts against a sanction.
Help me understand how this isn't just kind of a motion to dismiss gone wild. I mean,
a couple of things. Obviously, it's an enormous petition, so it's gnarly. But the motion to dismiss in this case relies on the same arguments as the motion to dismiss in the Hunter case. We get a decision in the Hunter case. An amendment is made, but doesn't actually change to any degree of great substance the claims made. Many of them, as the Court of Appeals pointed out, half of them still sought relief by certiorari. And it wasn't just a petition. So again, with the Open Meetings Act claims being saved, if the Open Meetings Act claims were the only ones that were pled, we wouldn't be here today. The other 18 claims are what counsel continued to press forward. So, there's a petition, but then there's a motion for TRO, a motion for emergency hearing, a motion for emergency hearing today, a motion for judgment on the pleadings, all of which related to claims other than the Open Meetings Act claims. And of course, if it was just the Open Meetings Act claims, there wouldn't be anything to enjoin because they were more than 6 months late. So they're not going to avoid any action of the Board of Supervisors.
Just address my concern directly, and I'll kind of phrase it this way. It seems like your problem is they start the case with the petition, and it's the throwing spaghetti against the wall. That there's a ton of claims, it's a super long petition, maybe some of the claims are frivolous. That's a fair characterization, I think, of your issue with the petition. Is that true? But then it seems like the sanction order suffers from the same defect, which is nobody gets into any specificity, and it's just a list of here's everything that was ever done in the case, and we think it's all sanctionable because it's fruit of the poisonous petition, and the judge agrees. And so it seems like we have the same defect on the petition that we do in the sanctions order, and that's kind of my trouble with it, and I want you to address that.
The only place you can look is the ruling on the motion to dismiss. And that has to be the district court's reasoning in the sanction order for why those claims were frivolous comes from the reasoning in the ruling on the motion to dismiss. From there, I do agree that from there, I think the district court's decision is from that point forward, each thing you filed was advancing these meritless claims. Thank you. I've run out of time several times here. I'll just end with Shenandoah Hills Wind respectfully request that the court affirm the district court in this case. Thank you.
Thank you, Your Honor. May it please the court again. I just want to address for some of these arguments that were just made by Mr. Leonard have already been addressed in the briefing, in the docket of Jennings. I first would point to the amended petition. Inside of there, I plead a number of facts to distinguish the facts in Fremont from the facts in the Mathis case that was just mentioned. And I also, in my briefing, D98, on pages 27 to 31, I put together a chart in there that went through each of the claims in the amended petition, what the Hunter, just how the Hunter decision would impact it, and a description why. And there are a number of them where the Hunter decision simply didn't address the issue because the claims couldn't have been made in Page County, such as challenging the road use agreements and the decommissioning agreements that Fremont County had adopted. There were no such agreements in Page County. I completely changed the way we were pleading the constitutionality question because of the general repealer making the argument that without specific amendments, every single ordinance in Fremont County, other than the wind ordinance, is vague because there's no notice to the public of what has changed in the other ordinances and who's supposed to figure out what conflicts and that is repealed. And that was different from in Page, where I was arguing the wind ordinance itself was vague. And then finally, I still don't know exactly what the district court found that I did wrong, other than didn't dismiss it because of Hunter. But Hunter, as you know, was appealed up the 8th Circuit and vacated on mootness and ripeness and is of no precedential effect. And really it can't at this point be a basis for a sanction when the Hunter case is not there for any real purpose. And, you know, if I had quit on my clients, I could have hurt their rights. And if you look at Iowa Rule of Professional Conduct 32 1.3, comment 6 clearly points out that one of the least diligent things you can do as an attorney is miss a statute of limitations, and conceding to the demand to dismiss Jennings would have allowed the writ of certiorari 30 days would have been gone as to the road use and decommissioning agreements already, and couldn't be rebrought. And you know, and I don't think there is other good faith challenge to changing, modifying the law to simultaneously be arguing that the Hunter decision is decided improperly through the 8th Circuit and simultaneously making the same arguments on the similar claims inside of the motions to dismiss in Jennings. The arguments were consistent and trying to indicate that Hunter was decided incorrectly and making those same arguments in Jennings. I think that's perfectly within the realm of 1.413. If you have a good faith belief that to challenge existing law, it's modification, revision, revocation. I mean, there are numerous examples recently in this court's history, overturning Godfrey. Well, certain that somebody lost on a motion to dismiss at the district court as that worked its way up through the system. And if there is a sanction of magnitude on a case that you know you're going to lose at the district court level because you're trying to change the precedent before this court, and that's sanctionable, those types of cases won't be reaching this court, and I think that would seriously damage the system of justice and a constant review of your decisions in the law in the state of Iowa. So, thank you.
The case of Law Officer Shawn Shearer and the Iowa District Court for Fremont County is hereby submitted.